Get ready for the dictation. Start. It is not in dispute that only married women are eligible for appointment to the post of Anganwadi Sevika. It thus bears relevance to consider the context in which the disqualification clause present at clause 3 Anga disqualifies married daughters. Apparently, the disqualification stipulation present in the said clause, insofar as a wife, daughter-in-law, and granddaughter-in-law is concerned, leaves no grey area. Rather, it is only in case of a married daughter, as in the present case, that the clause would require an interpretation and cannot be mechanically applied. A plain reading of clause 3 Anga of the guidelines dated 3/1/2006 perhaps, and giving a literal interpretation, would not give any other result than as impugned herein. The issue which falls for consideration is whether the prescription present at clause 3 Anga is to be read in isolation or has to be read alongside clause 3 Anga, which mandates that an applicant has to be the resident of the tola concerned in which the center is established, meaning thereby whether the applicant is a wife, a daughter-in-law, or a granddaughter-in-law, she has to be a resident of the tola village mohalla where the Anganwadi Kendra is existing. The petitioner states that she got married in the year 1992. She has also mentioned that her parental home is in the district of Vaisali, and though her father was a government school teacher at the relevant time, but since after her marriage in the year 1992, she has moved to her matrimonial home in the district of Muzaffarpur. Undisputedly, neither the husband of the petitioner nor her father-in-law holds any government post or any other post which would disqualify her from such appointment as found in clause 3 Anga. The question is whether in the circumstances where admittedly the father of the petitioner held a government post in the district of Vaisali, the said circumstance would be a disqualification for the petitioner to apply in the district of Muzaffarpur, where she is residing with her husband since after her marriage in 1992. In my opinion, any such disqualification would run counter to the object for which the provision has been stipulated. It is the object which is sought to be achieved under the provisions which has to be a guiding factor. In other words, the provision under consideration has to be interpreted with the object so sought to be achieved. As I have mentioned at the outset, the provision of clause 3 Anga is put to test in its application in the case of married daughters, and clause 3 G requires her to be a resident of the tola village mohalla concerned. Had it been a case where the parental home of the petitioner as well as her matrimonial home both would have been situated in the district of Muzaffarpur, perhaps then the circumstance that the father of the petitioner held a government post would have been an issue of disqualification, because in the said case the petitioner as a daughter was a permanent resident of the district of Muzaffarpur, and even after marriage she continued to be in the same district. In my opinion, the context in which the daughter has been disqualified under Clause 3 Anga of the Guidelines of 2006 inter alia on grounds that she is not related to a government servant has to be read in conjunction with the primary requirement of the applicant being a permanent resident of the tola oblique village oblique mohalla in which the center is established and cannot be disassociated with the said requirement as such is suggested by Mr. Trivedi. The reason is simple, and that is because it is only married women who can apply for the post. Although Mr. Giri, learned senior counsel appearing for the petitioner, has endeavored to suggest that it is considering its relevance that even such requirement has been deleted in the subsequent guidelines, but in my opinion it is the provision as it existed at the time of appointment of the petitioner in the year 2008 which would be a guiding factor and not the amendments made subsequently. In my opinion, stipulation present in the 2006 guidelines in force at the relevant time, insofar as it disqualifies a daughter of a government servant from appointment as Anganwadi Sevika as present at clause 3 Anga cannot be applied independent of clause 3 Ga, which requires her to be a resident of the same tola oblique mohalla oblique village. Rather, both stipulations have to be satisfied. Stop.